Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All right. And Ms. Harper, if anybody needs some assistance with the breakout rooms, Ms. Harper will be happy to help out with that. I am going to go ahead and call position number 2. I'm going to go ahead and start hearing that case. It has been continued from a previous calendar, and it's my understanding that negotiations are not going to be helpful. So I'm going to go ahead and start in with that case. Let me just get it pulled up. Open up the calendar I was looking for. This one. Okay. All right. So Ms. Range, you represent Ms. Maddox. Is that correct?
Yes, Your Honor.
All right. So this is position number 2. Plaintiff. Okay. So Ms. Kappelman and Mr. Price, the way this is going to go is the petitioners go first. Typically, it's they're presenting the case, so they're going to go first. When Ms. Range is done presenting her case, you will have an opportunity to ask questions of their witnesses, of her witness. If I don't know if there's multiple ones or just one, but you'll have an opportunity to ask them questions. And then when they've rested their case, you'll have a chance to testify on your own behalf. And then Ms. Range will have an opportunity to ask you guys questions. Okay, so that's sort of more or less how it will go today. All right.
Your Honor, can I just confirm that my court reporter is able to take this down?
Okay.
Okay, great. Thank you.
It's like she's here. Okay, she's on 2. I guess she's on 2 different devices. Okay, I can see. Okay. All right. Miss Osley, do you need some help getting to where you need to go? Nope, it looks like she's good. Okay. All right, then Miss Range, I am ready when you are.
Judge, would you prefer that I swear the witness in, or would you like Ms. Howard to do that?
Actually, I can go ahead and swear everybody in. Mr. Price, Ms. Kappelman, if you could unmute for a moment, and Ms. Maddox, if you could all please raise your right hands. You got to unmute. Okay. Ms. Kappelman, you got to raise your right hand. Do you all swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Okay.
Yeah. Everybody responded verbally. You can all put your hands down now. Everybody's sworn in. Okay, go ahead, Ms. Range.
Thank you so much, Your Honor. Ms. Maddox filed an affidavit contemporaneous with her petition and outlined all of the information and more that we're going to go over today with accompanying exhibits. So I will try and be brief with her. And if there are any questions, I believe they'll appear in that affidavit as well. Ms. Maddox, can you please state your name for the record?
My name is Mary Maddox.
And can you hear me okay, Ms. Maddox?
Yes, I can.
And the property at issue that we're talking about today, can you give us the location address of that property?
33.
And what county is that in?
DeKalb.
Is that a single family residence home?
Yes, it is.
And is that where your mother resided before her death?
Yes, she did.
And what is your mother's name?
Beth Darden Nutting.
And at the time of her death, was that property owned exclusively by her, to your knowledge?
Yes, it was.
And after her death, did her home become part of her estate?
Yes, it did.
Are you the executor of that estate?
Yes, I am.
And just a couple questions about the status of that estate. You were appointed executor by the probate court, correct?
Correct.
And that was part of your affidavit that you executed in this case, right? You submitted that order to this court reflecting that information.
Correct.
And a will from your mother, has it been accepted for probate or admitted to probate in Bleckley County?
Yes, it has.
So are you, is it fair to say, in the process of trying to resolve the estate for your late mother, Miss Nutting?
Yes, that is correct.
We're not going to go over all the probate proceedings, of course, but were any competing wills provided to the probate court when you attempted to probate your mother's will?
No, none were provided.
And who are the heirs to your mother's estate?
I'm sorry, can you repeat that?
Sure. Who are the heirs to your mother's estate?
I am an heir, and my sister Barbara Kappelman is an heir.
And as executor, when you filed your petitions and all the paperwork you filed with the probate court, did you provide notice to all the heirs, meaning you and your sister in that case?
Yes, it was provided.
Were any objections filed by Miss Kappelman, your sister, or anybody else to the probate of the will that you referenced earlier?
No objections filed with the court.
Okay, so do you currently have permission from the probate court to try and sell the residence that we're here today to talk about?
Yes, I do.
Okay. Well, we've got to take care of this eviction first. Is that right?
That's correct.
Okay. So let's take just a step back. How is Miss Kappelman related to you?
She is my sister.
Okay. And Joshua Price, the other defendant in this case, is he related to you?
No relation whatsoever.
And is he an heir at all?
No, he is not.
Okay. So to the extent that he is wrongfully in the property that formerly belonged to your mother or currently belongs to your mother's estate, to your knowledge, is he there at Miss Kappelman's request?
That is my assumption.
You have not given him permission to be there, is that right?
No, I have not.
When did Miss Kappelman and Mr. Price first begin residing at your mother's house?
Mr. Price began residing back sometime in, I believe it was 2020 pre-COVID.
And your
Or during
sister, Miss
COVID.
Kappelman?
She has lived there since her divorce from Mr. Kappelman.
Was your mother still alive at the time that they were living there initially?
Yes, she was.
And was that, were they living there with consent of your mother at that time?
I do not know the answer to that question. My mother never said that they had permission to both be living there. My sister, yes, but not Mr. Price.
Okay, so near the end of your mother's life, was she moved to a nursing facility?
Yes, she was.
And at that time, was a conservator appointed to handle her affairs?
Yes, there was. Her brother.
And was that conservator appointed by the probate court of what county?
DeKalb.
And the conservator, excuse me, was that your uncle, Mr. James Darden?
That is correct.
Did your uncle, Mr. James Darden, give permission as conservator for Miss Kappelman or Mr. Price to remain at your mother's home?
No, he did not.
And after he was appointed, did the probate court, and I'm talking about the appointment to conservator, Did the court give permission for him to sell the home to pay for your mother's living expenses, managed care expenses?
Yes, that is correct.
Did your uncle send Miss Kappelman, Miss Price, a demand to vacate the residence?
Yes, he spoke with him and met with him in person.
No.
And this is also in your affidavit, but did he cause them to be served with a dispossessory action in about June 2020?
Yes, he did.
And did your mother die shortly thereafter?
My mother died in July of 2022.
Okay. And after the demand to vacate, did the magistrate court enter a judgment in favor of your uncle as conservator to that your sister, Miss Kappelman, and Mr. Price were tenants at sufferance in the home?
Yes, that's correct.
Okay. Did the court also find that your mother was the sole owner of the property?
That is correct.
And did an eviction take place in December 2022?
Yes, it did.
And the eviction, to your knowledge, Miss Kappelman and Mr. Price vacated the premises of your mother's home. Is that right?
That is correct.
Okay. And you were appointed executor. We talked about this before. Did that take place in March of 2023?
That is correct.
Okay. And did you take some steps to clean up the property and secure it?
Yes, we did.
Nevertheless, did the defendants return to the property?
They did and broke in.
So is that to say that they did not have your permission to re-enter the home?
They did not have my permission.
And in May 2023, did they call you from the property indicating that they had broken in?
That is correct.
Now, we're not going to go into this in depth because I know that there's a lot going on with this right now. But during the period after when they were living there wrongfully as trespassers, or prior to that, tenants at suffrage, did the property incur code violations from the local municipality?
Yes, it did.
Okay. And like I said, we're not going to talk about all of them. I do believe some of those were submitted with your affidavit, or at least particulars regarding those were submitted with your affidavit. But is it fair to say, and I'm asking you this in your capacity as the executor, is it fair to say that the property has diminished in value since the time that the defendants began wrongfully residing there?
Yes, it has.
And does it continue to diminish in value?
Yes, it is.
Okay. And is it your obligation to, from what you understand, based off of your oath that you took with the probate court, to protect the assets of your mother's estate, principally the home that we're here today to talk about?
Yes.
All right. And to that end, March of this year, did you cause Mr. Price to be served with an eviction notice?
Yes.
And then I think shortly thereafter in April, did you cause Ms. Kappelman, to be served with an eviction notice?
Yes.
And you executed an affidavit attesting to all of those things, and the service has been filed with the court. So you are here today to ask the court to find in your favor to again order the eviction so that you can clean up the property, secure it, and sell it. Is that right?
That is correct.
And under the terms of the will for whom you are executor for your mother, if you sell the house and resolve any indebtedness, who is going to receive any leftover funds?
They're to be split between me and Ms. Kappelman.
All right, so ultimately, Ms. Kappelman stands to benefit so long as she leaves the
Agreed.
property and doesn't come back and allows it to be
Why is
sold.
it such vested from original
Correct,
will?
that is correct.
All right. Your Honor, I don't have any more questions for Ms. Maddox.
Okay. Are you, I think just, I know that there is a detailed affidavit, but I do think that if you want any documents officially, I think they do need to be entered into evidence if there's any sort of.
We never had any delivered to us at this house at all.
Okay.
No,
Not in, this is not your opportunity. You will have a chance when you, and it's your turn, okay?
I'm sorry, Your Honor. So the documents that have been filed with the court also need to be admitted into evidence. Is that your query?
Correct, yeah, I think so, yeah.
Then yes, Your Honor, if we could submit those as well.
They're mostly judicial documents that I can take judicial notice of, is that correct?
Yes.
Okay, let me just, I've reviewed it. Hold on one second. Where did it go? All right, there's the detailed affidavit on behalf of Ms. Maddox. That she can
Here's
be
the-
questioned about anything on the affidavit. We have an order admitting copy of will to probate in solid form.
then the will was produced.
Okay, folks. Okay, let's put them on mute. Thank you. All right. Letters of testament, okay, in the estate of Beth Darden, letters of testamentary. State of probate, Bleckley County probate's office, letters of testamentary issued, executor of the estate, Beth Nutting. Final order. This is the order granting conservatorship to Mr. Darden. Final order of judgment. Counsel, but neither defendant, Kappelman, or Joshua Price appeared, receiving proper notice. The court enters the following. That Beth Darden Nutting is the sole owner of the premises. Darden was appointed conservator. Beth Kappelman and Joshua Lee defendant are in possession, and they are tenants at sufferance. Let's see, hold on. All right, so this is the previous dispossessory, James Darden. This is filed by James Darden versus Barbara Kappelman and Joshua Lee Price. Again, it does establish that Ms. Nutting has already been established as the owner, that Ms. Kappelman and Joshua Lee Price did not appear, but that it was found that they are in possession of the property and tenants at sufferance. Plaintiff made repeated demands for possession of the property, including written demand through counsel. Defendants have not complied with the demands for possession, have not surrendered possession, and remain in the property. Defendants have paid no rent during the interim period. Defendants failed to appear for the hearing after receiving sufficient and proper notice. Accordingly, a motion to strike the answer is granted and a default judgment is entered. It's hereby ordered that default judgment is entered in favor of the plaintiffs against defendants. That plaintiff is entitled to possession of the premises, possession. The plaintiff is entitled to apply for a writ of possession. The judgment in favor of plaintiff gets the rent period of sense. And they were ordered to pay $1,200 per month for, they were ordered to pay, if appealed, $10,800 at the time. And this order was signed by Judge McNeil on September 1st of 2022. So there's already an eviction. They've already been told they are not in legal possession of the premises. There was a writ. Code compliance. I guess that's not technically. Okay. I guess the only things I really can't take judicial notice of are going to be these the code violation paperwork.
That's no problem, Your Honor. She testified to the existence of the code violations and
Yeah.
it's only borderline germane to the topic at issue.
I'm just going through, just taking me a second. I looked at it earlier, but there's kind of a lot.
There is, Your Honor.
Okay.
And the affidavits of service are also on file in the clerk's office if we need to make those, so officially tender those as evidence. We
If
could
that's
do
in the
that.
file, that does not.
Okay.
Okay, these are just the repeated. Okay. Okay, so there's the code violations, and then we have, I think you need to, it looks like the eviction notice. I think you would need to enter that into evidence with your, I don't think I can take judicial notice of that. All right, so Mr. I guess Mr. Price is not really, he's not on the lead. There's no legal relationship here with Mr. Price, correct?
That's correct.
Aside from being an occupant. Ms. Kappelman? If you could unmute me, please, and come a little closer to the camera. I can't see you. All right, Ms. Kappelman, so reviewing the affidavit that was submitted by the plaintiff, there are majority of the documents in there, anything that is a official court document. I plan on taking judicial notice of those things. I'm just going to ask you if you have any legal objections to me doing that.
I'm not understanding what you're saying.
I'm going to take any official court documents that have been submitted by the plaintiff in her affidavits. I have the authority to take judicial notice of those documents. I plan to do that. I'm just asking you if you have some sort of legal basis for me not to do that.
No. But I'd like to know why we didn't get a copy of any of that.
Okay. All right. I'm not hearing any legal objections, so I'll take judicial notice of the official court documents. But like I said, that does not include the code enforcement violations or the recent demand, because I think that needs to be entered with by the plaintiff. So was that did you have any further questions, Ms. Range, for your client? You're muted again, sorry.
Rookie mistake. Your Honor, should I email those pieces of evidence to that dispossessory email link, and then I can ask Ms. Maddox about it right now? Is that how you'd like me to continue right now?
Yes, I guess I could. So yeah, I guess go ahead and just email it in. You're technically supposed to have that already emailed in to like on the court notice. I could probably just share my screen, but if you want to go ahead and just email it to Ms. Harper, you can do that.
And Ms. Harper's email address,
I think she'll send it to you in the
she'll
chat.
send it to me. Okay, great. Thank you. I think I have a general email address on the notice, but that might not be the most direct
Yeah.
route right now.
While that's going through, do you have any other questions for your client?
Just related to that piece of evidence, Your Honor, Ms. Maddox, did you sign a letter, an eviction notice? Excuse me. Did you sign a document and cause to be sent a document called eviction notice, the date of March 21st, 2024, to Ms. Kappelman?
Yes, that is correct.
And did you also send one to Mr. Price?
Yes, that is correct.
Okay. And did you send both of those? Were they both addressed to the property that we've been discussing today?
Yes, that is correct.
All right. And you signed those documents?
Yes, I did.
And did you hire a process server to serve those documents? That notice,
Yes,
excuse me?
Yes, that is correct.
And is it your understanding that that service was accomplished and an affidavit of service to that effect has been completed?
Yes, that is correct.
Your Honor, those are the rest of my questions for my client. If Ms. Harper's going to send that in the chat, I haven't seen it yet.
You know what? I think I lost Miss Harper. She'll come back in just a moment. We'll go for it. I think
Sure.
I got it. Like she testified. The date on the notice was what? Actually, hold on a second. It was already submitted. I had another case that the guy, he just had no ability. He had no scanner, no nothing. Like there's nothing I can do, but it's already in the file. So hold on a second. Okay, I'm going to famous last words here. Here we go. I'm going to share my screen. Everybody see, what do you guys see? Do you see it?
Yes, Your Honor, I see it. Do you see it, Ms. Maddox?
I do.
Okay. All right. So you want to ask, this is the eviction notice.
Yes, Ms. Maddox, this is the eviction notice that we were just talking about. And this one in particular is addressed to Joshua Lee Price.
That is correct.
And does your signature appear at the bottom of this document?
Yes, it did.
Thank you, Your Honor.
All right. Is that the only, is that it?
There's one for Ms. Kappelman as well. That is the affidavit of delivery for the eviction notice for Ms. Kappelman, Your Honor.
So this is the eviction notice that you were referring to?
That is actually the affidavit of the process server.
Sorry. Okay. Yeah. How about that?
But-
Okay. Here we go.
Yes, there you go. Ms. Maddox, this document right here that is titled eviction notice, it appears on your screen, March 21st, 2024, and is addressed to Ms. Kappelman at 3. That the eviction notice we were just talking about that you caused to be sent via a process server and has your signature at the bottom?
That is correct.
Okay. So those are the only, all right. So Ms. Kappelman. All right. Are you able to state any legal objections to the omission of these two documents?
Well, for one thing, I didn't get that piece of paper until on my birthday, May 22nd. So I don't know how it was filed in March 21st, when I didn't get it 2 months later.
Okay. So you can testify about that, but in terms of
And
legal,
also, we have the original will that was signed by the judge with the ribbon. And she knew I had it, and she doctored up one and sent in and said lost will, even though I told her I
okay,
had it.
this, I mean, I'm just asking you for a legal objection. It doesn't sound like you have one, so I'm gonna admit both. I'm gonna call these P1 and P2.
What do you mean? I'm not prepared for all this stuff because everything she's saying is not true.
Okay, well, you're gonna have your chance to tell your side in just a second, okay? All right. All right, can I stop sharing my screen?
Yes, Your Honor.
Okay. All right, Ms. Range, do you have anything else you want to present for with your client?
Not to present with my client, I did just want to confirm, we did not receive an answer from Ms. Kappelman. There was a document titled answer that was filed from Mr. Price. But we did not receive and we did not see anything in the docket. And I just wanted to confirm with the court that that is accurate, because of course, sometimes electronic.
I did not
documents
see
always
any
take it.
answer. Hold on, there was amended answer filed later. Let me see. There's a very late filed amended answer by Ms. Kappelman that was submitted on June 7th.
Does it reflect any service on anyone?
It just says it was filed. It was. And there's just pictures that I can't read about the will. Hold on, I'll share my screen. Hold on a second. You should have received an e-notification of it when it was uploaded. Here we go again. Can you guys see that?
I can.
Okay.
We received several notifications from the court about the hearing, but not this answer.
It's on there. I like the will. She's purporting to have attached a copy of the will to it, but it's not. I can't read it. So but that is attached to her answer. And then there are pictures of debris all around the property. I'm assuming this is the property. Yeah, pretty bad shape. Okay. All right. Can I stop sharing my screen now, or?
Yes, Your Honor, thank you.
Okay. All right. All right, Ms. Range, anything else?
No, not for Ms. Maddox, Your Honor, no.
Okay. All right. So Ms. Kappelman.
Yes.
All right, Ms. Kappelman, this is your opportunity. If you choose to ask Ms. Maddox any questions, it's just questions.
Why are you doing this? Why are you going against the will? You knew I had the will.
Let me, ma'am, I'm going to leave some parameters here. You're not going to interrupt anybody. You're going to speak in turn. You're not going to raise your voice. You're going to speak like civil human beings to each other. Okay. And you're not going to interrupt me either. Okay. So just calmly and ask her questions. You can ask her what you need to ask her, but be civil about it. Let her finish her answers, and then you can go to your next question. Okay. And please do not speak over me or anybody else. Go ahead.
I'd like to know why she's doing this. Why
Okay,
she has to
this is
write
not,
a will.
ma'am, this is your chance to ask her questions. It's not to state why you think she's doing it. Ask her some questions if you have any, and if you don't, that's
I don't
okay.
even have a lease. I never signed anything. Nothing was presented to me. I've been here.
Are you going to ask her any questions or not?
I don't know what to. I want to know why she's doing this.
Okay, that's a question, Ms. Maddox.
I've never done anything like this to her in my whole life.
I can't understand her, Judge. I'm sorry. If you could help me out, I appreciate it.
Ms. Kappelman, like I said, if you are going to be participating today, you're going to have to not interrupt, speak clearly and slowly. If you have any questions, you were asking Ms. Maddox why she's doing this. I'm going to allow her to answer your question, Ms. Maddox.
I'm doing this to settle the will. Neither one of us can afford to keep the house. It has to be sold to settle the will.
Settle the will. I was just
Ms.
getting a month.
Kappelman, do you have another question?
Why am I not getting my money that I'm supposed to be handed to monthly? I haven't received anything at all.
Mr. Price, put your hand down. You're gonna-
Objection, Your Honor, that doesn't seem to be relevant to these proceedings.
Okay, I couldn't really even understand her. What did you say, ma'am? Could you put the phone or whatever it is you guys are using a little closer to the person so I can hear her?
In the will, it stated that I'm supposed to be given a certain amount monthly to help out with doctors or bills or whatever, and I have not received $1.
Objection, Your Honor, that's not relevant to these proceedings.
It's really not, but Ms. Maddox, go if you can answer it, go ahead and answer it.
There are no such provisions in the will. We are to split the
Yes,
assets
there is. The original
equitably.
will.
Okay,
not
we're
have.
not arguing. You're not arguing at the moment. Do you have any other questions?
I'd like to know why she had to make up a new one when she knew I had the original one. My son read the original one. Why they're acting like there was one that was lost when I said I had it the whole time.
Objection, Your Honor, the will has already been admitted to probate, and so this is
One
not the
was made
appropriate
up.
forum to contest the validity of the will.
Not the original one.
Okay. If Ms. Maddox, if you're able to answer her question, go ahead and answer it.
Will has already been probated legally through the court. in
No, it
Buckingham
has
County.
not. I
All
haven't
right, Ms.
seen anything.
All right,
I
Ms.
haven't signed
Kappelman,
anything.
this is
Sure.
not this is not your time to argue. Next question.
Who's doing it for me? Because I haven't signed anything or seen anything.
Ask a question, ma'am.
Who is acting as me?
Who presented the lease?
Okay,
I
ask
never got
another
a lease.
question. That's
I
not
never
even
got anything
that's not even a
signed.
question.
I didn't have anything read to me. I have been left out of the loop altogether.
Barb,
Ms. Kappelman, do you have another question? If not, I'm going to move on.
I asked you a bunch of
Ms. Kappelman,
I'd like to know why she went against the will, knowing that I had the will. And then he misspelled my name. They rewrote it. We have a signed letter, an affidavit from the lawyer that drew it up, saying the whole page is missing out of it.
all right. Ms. Maddox, if you can answer that question.
The will has been probated legally through the court.
Same.
The issue of the will and the
Why?
validity of
Here's
the Kappelman is it's already been established. I've let you ask a few questions about it, but I think we've covered that matter. Do you have any questions about anything?
I used my own money to fix up this place.
I know.
Okay. It doesn't sound like Ms. Kappelman has any more questions.
I don't know what to say because I've been cut off left and right.
Don't yell.
All right.
It's not her fault.
So Mr.
I'll get
Price
the
is
lawyer
not,
though.
okay, Ms. Kappelman, I'm going to remove you from the proceedings if you keep interrupting. All right. All right. So Mr. Price is not technically, I mean, he's a named party, but I don't know that he's an actual, I don't know. In abundance of caution, Mr. Price, please put your hand down. I see that I'm giving you a chance. This is your chance. If you want to ask Ms. Maddox a couple of questions, you can go ahead and do that.
My first question is, who produced a lease agreement to get a judgment on us that was never presented or discussed, or you had never met me?
I
'Cause
don't
I lived
understand
here
your
before
question.
your mother passed. For a year before she passed, I was here. Been here for 5 years. I've never met you but one time, and I've tried to talk to you many times.
Okay, again, question.
Amen. George.
Ms. Kappelman, I'm going to remove you if you keep interrupting.
I'm sorry, Your Honor. She's emotionally distraught over this matter and was hospitalized over it.
Ms. Maddox, if you can answer whatever, I'm not sure I understood the question either, but if you can answer it, go ahead.
The will was probated legally. I don't understand the 5 years. I don't know what that's all about. But we're following my parents' intent in the will.
Okay, Mr. Price, do you have another question for Ms. Maddox?
Yes. That didn't have, that answer she gave was based on none of the question that I asked. I asked, how was a lease brought to the court and presented to the court to get a judgment that I'd never seen or signed? That was the question that I had asked, ma'am. Because I've done
Okay, so
nothing
Ms.
wrong.
Maddox, do you have an answer for his question?
Process server served the papers for eviction to the address to Mr. Kaplan. I mean, to
I'm
Mr.
evading
Price.
the questions.
Objection, Your Honor. I think Ms.
I think-
Maddox is trying to answer the questions, but she's just unable to understand what Mr. Price is asking.
I agree. Mr. Price, do you have any more questions?
I was I'm not trying to be a smart butt, but that was a pretty clear question about who presented a bogus lease to get a judgment on us when the will clearly states, if you read the pages on it, that
Mr. Price,
she's
the judgment was based on tenants and sufferance. There was no
they're
lease.
manipulating the wording of the legal documents and filing false accusations.
Okay, that's not a question, so I'm gonna give you a chance to testify in a second. Do you have any questions? You get one more question for Ms. Maddox.
When's the last time you actually spoke to me?
Objection, Your Honor. I don't see how that's relevant to the proceedings today.
I think it is.
Ms. Maddox, go ahead and answer if you can.
'Cause I have documentation.
I don't see that it's relevant that I speak with Mr. Price. He is nothing to me. He is no relative.
All right, Mr. Price, she's answered your question. Do you have any other questions?
Yes. Okay. The question that I have now is, why is it that Ms. Barbara has reached out numerous times to try to speak with her, and I have documented these phone calls with the phone company with the data transcript that I requested, and they don't return phone calls. She told me personally on the phone. Well, that's relevant, but either way, I don't know what to say because I know we're being railroaded here. Oh, citations. What citations have been given on this property? Because we've gotten one warning, and that was it. And it's in full compliance because I worked around the clock and got the property cleaned up so the family would not get fined $1,000 a day for us helping a friend.
Sir, that's not a question.
Ended up in the hospital 5 days to make sure it got clean.
Okay, it sounds like he doesn't have any more questions. He's just
No,
making.
I'm bamboozled about all the lies and deceit from this family here.
Okay,
Oh my, I don't know who the family is.
all right.
I've
Ms.
never.
Grange, do you have any other questions? Do you have any other case? Anything else for your case?
No, Your Honor.
All right, it doesn't sound like they have any more questions. All right, so Ms. Kappelman, this is going to be your opportunity to testify on your own behalf.
You're loving.
And then Ms. Range, if she chooses to ask you, she will do
Letters
that.
done why I should be able to stay in the house.
Yes. What's it does?
So when do I get to submit that?
Ask the judge.
All right, Ms.
Letter that you asked me to write, or asking why I think I should
Kappelman, I'm
stay.
having trouble understanding what you're saying.
She was wanting to know when she can state the letter that she wrote of why she should remain in the house, is what she's saying. If she could read
To
you her letter.
explain, Ms. Kappelman, you can tell me now why you feel you have the right to stay in the house. This is your chance to say that.
Why? I stayed here. I worked full time and took care of my parents. I moved back home over 20 years ago. And then when they needed extra help, I cut my hours back and I helped because they helped me. I thought it was time for me to step up to the plate to help them. And the fact that she's doing this and she never came up, we begged her to come up to help out, and she always found some other reason not to. And her students wouldn't learn the substitute and all kinds of craziness. I worked 40 hours or more a week and took care of them until Daddy died, and then I had to cut back everything. And I took care of my mother rather than pay someone. All the money we made, I took care of her. I had some people help me out with some things, but I had to technically walk away from my job so I could help my mother. Because I felt I owed it to my father and my mother to do this because they always helped me. And my son, I don't understand who my sister is anymore because I don't know her as this person. I found pictures of her and a whole nother family of a girl that looks like her but younger. I'm just totally. I'm like, she's got two families now.
Stay on course.
Daddy told me to find a good home for all his books. She threw out half of her inheritance, got thrown out in the yard. She had the whole house thrown out. My parents saved over 2 decades worth of stuff from all over the world.
What we do?
And we didn't get any of it. She threw it out in the yard. People stole it in our neighborhood. First edition books that were signed by the authors with the letters written to them.
Everything.
Antiques, jewelry, passports, everything was everywhere. He worked 4 hours, 4 days, hours by himself to put stuff in 2 storage rooms, which she let go. What we could save. She quit paying
I
it.
didn't have to do that.
We gave all the money we could to get the truck and get the first 2 months rent. I watched them break my parents' furniture, all of their antiques, everything they signed, heartlessly on the front lawn. They barely let me put clothes on. She never came out when we asked her to help out when they were alive. Now she thinks she owed something. Where was she when all this was going on? I'm the one that took care of all of it. I fixed 3 dinners every night because everybody had to have something different. I took them to the doctors. I took them to a garage dinner. I took them to the grocery store. My
Your
father,
Honor, I'm trying to be respectful, but I think I need to make an objection for the record.
For a little more leeway, and we'll move on in a minute. Good. Did you have any other, and again, Ms. Kappelman, you're not really addressing the
I have
I understand. you're
pages here, okay?
The pictures that were submitted shows that we're improving the property.
This is not your, sir, your.
We painted
Tell
and
her,
put branded
Barbara,
furniture.
they're not going to listen to me.
I got all this stuff. We sent pictures. We had nothing left. I had 4 chairs when I made back in here that I got out of the tool shed.
Okay.
We built up the floors. We put hardwood floors on them. We took all the carpet out. We painted. We put all the curtains up. We just finally got some new furniture that we've been slowly put pieces back in place. We've been
Okay.
trying to
Ms.
redo.
Kappelman, Ms. Kappelman,
Hey,
Because
calm down. I
you're
know.
not
nobody has
addressing-
helped us do anything.
you're
We
not
spent our own
addressing
money.
case against you today.
And then I was in a car wreck.
Hey, listen to what she's saying, Barb.
You're not being responsive to what the case is today against you.
Because I didn't never sign anything. I never received anything in the mail at all. I wasn't at that court reading. They never did a reading of the will. I have the will.
All right.
Why did you stay in your home?
Why I should stay here? Because I feel I'm owed you. Because I helped out, and I'm the one that did all that. She
Okay.
didn't.
Okay. All right. Ms.
Too
Rain,
busy
do you have any?
for other family.
Okay. Do you have any questions for Ms. Kappelman, Ms. Range?
No, Your Honor.
Okay. All right. So, Mr. Price, you will have now an opportunity to say your piece.
For my case is
Well,
I've
it's
been
it's
donating-
yours. I mean, I'm not even sure you're really technically. Go ahead and testify. Go ahead. Say whatever you
I've
need to
been
say.
donating all the work material, all the building materials. I've redone the floors in this house, patched the walls, because over the course of the family living here, the father was very brutal about fixing things. And so that's what I've been doing. I've uploaded pictures and all for the courts to see.
Price, this is either one of
Hold on, calm down, please.
what way.
See, when we got evicted before, it was a very dramatic event for Barbara. That's when we found out about separation anxieties and stuff from material things. So she's worked up right now. But I've been the one cleaning up. Any citations that were given, no one in this house has seen them. You know, because right now it's still an open pending case for on the 23rd of this month that there has been no citations. It's been a warning, and I've got it in compliance now with the code enforcement officer is supposedly dropping the case because I've gone over and beyond improving the property.
Okay. So,
You know,
Mr. Price, did you get a chance to look at the answer that Ms. Kappelman filed on June 7th with those pictures?
Yeah, from where we're doing the flooring and stuff.
the mattresses on the yard, debris
That was
everywhere.
from the eviction.
eviction
Hold on,
pictures.
calm down. On
Okay.
December 19th is when they did the eviction. The judge never seen the order, seen the case until December 20th, and didn't make an order until December 21st.
Okay.
Damn, my phone. Call the clerk of the court.
Okay. All right. Ms. Raines, did you have any questions for him?
I
He's-
don't
he's
think
signing
he's
it.
on the line anymore.
Okay. All right. I think they have said majority of what they were going to say. Were you going to ask him any cross-examination?
The only thing I wanted to inquire about, Your Honor, is whether Ms. Kappelman
Okay.
was under the
Well, then
influence of drugs
let's see if
or
they can
alcohol.
get, I'll have Ms. Harper, if you could contact them and tell them that they need to get logged back in. I'm not gonna continue the case. I will go ahead and take Mr. Bennett's case really quickly, and we'll come back to this one and see if they can get logged back in that meantime, and then we'll finish up.
Thank you, Your Honor.
Happy New Orleans.
There we go. It's working now. Okay. All right. If I'm not mistaken, we left off with Mr. Price, was talking about having done work on the property, I believe is what he left off at. So Mr.
Yes,
Price, if you have anything else to add, this is your opportunity to go ahead and add it. And then I will have, if Ms. Range has questions for you, I'll let her ask you some questions at that time.
I have previously reached out to our neighbors, which is a lifelong friend of the Nettings, which I understand married to be in contact with the hubs that live across the street on a weekly basis. I've reached out to numerous times and been there for when they've talked on the phone to try to reach out to resolve the matters in between the two sisters, to communicate what she wants done with the property. She hasn't responded to me because I'm like the mediator with Barbara, the same as Ricky is her husband, and I'm on their side. I believe the sisters need to talk and work this out and come up with a plan for the property. But they put us out December 19th before Christmas, put all the family's possessions that they worked their entire life for out in the front yard for anybody to steal. The people that did it broke a lot of the antiques. So for 4 days after this eviction, in the rain, by myself with no help, I hustled up and got the money for storage and put everything in storage that I could salvage. And the sister Mary paid for those storage units for 3 months. Not once would she come and view anything or anything from the storage unit. Then ultimately it got taken from me by them, but we haven't been given notices, no communication. I know my name's Price, but I was here when Miss Beth was living with agreement with her, and my phone still on?
You just turned your camera off again.
I did.
You have to turn your camera back on. Mr. Price? Mr. Price? All right, folks. All right, at this point, I think we've been patient, and the truth is, I don't feel that Ms. Kappelman or Mr. Price has stated anything that were really relevant to the actual any sort of defenses, any sort of legal defenses or counterclaims to the actual dispossessory that they're facing. So I will, Ms. Range, you're not going to have an opportunity to ask them questions at this point. I think they've officially left the proceedings again. I'm going to go ahead and find that they are, let's see, your warrant was filed on trespass. I think they are trespassers at this point. They were already evicted as tenants at sufferance. At this point, they are trespassers. The writ of possession, we'll go ahead and give them 7 days from today's date for the writ to be available. Although I think technically it could be due since it was, hold on. I'm sorry, I was just going rambling. Okay, 7 days from today's date is 11:59 p.m. on the 19th of June. And so that will be when the writ is available for a notice provision. I'm sorry, for an appeal provision. What was there any rental payment prior to? Was there ever any rent paid by these folks?
No, Your Honor.
Okay, all right, so there's been no evidence regarding fair rental value of the property, so it will just be a possession only. I don't think I can put up, since there's been no evidence presented as to the fair market rental value, I don't think I can put in up an appeal provision here for that, so it'll just be possession, okay?
Understood, Your Honor.
All right, anything else?
No, Your Honor, we appreciate your patience.
All right, thank you, have a nice day, bye-bye.
Thank you, you as well.